Welcome to the Virtual Spring Meeting 2020, brought to you by the American Bar Association Antitrust Law Section. The Spring Meeting is the section's premier event, a multi-day celebration of learning and camaraderie. The Virtual Spring Meeting brings together the world's leading experts on competition, consumer protection, and privacy law, discussing the most compelling issues of the day. Enjoy the show.
Hello, and welcome to the Virtual Spring Meeting. Today we have yet another great panel. It is Common Minority Interests, Major or Minor Problem. The panel is presented by the Insurance and Financial Services Committee. And with me today to provide some context are two experts. Amanda Norton is an associate at Sidley, and she was the one that put this panel together. She was the session chair of this panel. Hi, Amanda.
Hi, John.
And we also have Megan Browdy. Megan is a partner at Cooley LLP and is also a vice chair of the Federal Civil Enforcement Committee. Hi, Megan.
Hey, John. Delighted to be here.
All right. Well, Amanda, since you put this together, let's start with you. What is today's panel about?
Well, John, in essence, our panel today is about the investing practices and the holdings of large institutional investors in our markets, the BlackRocks, the Vanguards, the Fidelities of our world. We all know that these investors diversify their holdings to manage risk. That's nothing earth-shattering. But what that means is that if you take a look at any one of those investors' holdings, you're likely to find that they hold stakes, albeit small stakes, we're talking 5, 6, 7%, in multiple firms within a given industry, some of which may be competitors. So the panel explores a question that's been receiving increasing attention recently. What are the competitive effects, if any, of the fact that these common owners exist in particular industries? Do these common owners harm competition at the firm level in any way? And the core intuition behind that theory is that firms seek to maximize shareholder profits. So if executives of, say, 2 or 3 competing firms knew that they had a shareholder in common, does that common shareholder give the firms the incentive to soften competition among them and thereby raise profits, perhaps industry-wide, because a rising tide lifts all boats?
Megan, why is this important?
So, John, this is a new and emerging area that could have really significant consequences for consumers. And while I don't think we're going to hear much of disagreement that it could have significant consequences, what the right paradigm for enforcement is, and whether that's antitrust or otherwise, is still very much up in the air. As I suspect the panel will discuss in more detail, over the last several decades, we've seen a shift and who owns these publicly traded companies, as Amanda was foreshadowing. And I don't suspect there will be much debate on that basic fact. But whether that consolidation in ownership has a significant impact on competition, and if so, what to do about it, is a really critical question that we need to dive into. So today's panel is going to help us to get closer to answers on those questions, or at least think about what we know today and the arguments for different approaches, which is critical to figuring out whether we have a problem to solve and how to solve it.
Great, thank you. And Amanda, what are we hoping to learn?
So the million or probably billion-dollar question is whether common ownership is an antitrust problem. How, if at all, does this harm or benefit consumers? John, are you and I paying higher prices for airline tickets because Fidelity owns stakes in Delta, American, Southwest, United? Or are we going to be able to retire earlier because these investors are able to diversify their holdings in the way that they do? And how can we balance those potential effects? Secondly, as Megan mentioned, this is an emerging area of the law. So I'm also looking to learn more about what, if anything, the US agencies are doing in this area. I'd also like to hear whether our panelists have any thoughts on what the agencies can be doing in this area and what they should be doing in this area. Finally, given all the uncertainties that cloud this emerging issue, I'm also hoping that our panelists can offer something in the way of practical advice for clients in order to manage this potential risk.
Great. Okay, Megan Amanda, will you stick around for a few minutes? Let's stick around and watch the panel together, and then maybe come back together and we can talk about some of the takeaways. Is that okay?
Great, looking forward to it.
Same here.
All right, super. Well, then let's send it down to another Amanda Waite, who is the moderator of today's panel. Amanda, down to you.
Thanks, John. Welcome to our video cast. My name is Amanda Waite, and I'm a partner in the Washington, D.C. office of Norton Rose Fulbright. But today, I'm coming to you from my home office in Arlington, Virginia. My kids are upstairs, so if you hear a loud thunk, don't worry. They should have adult supervision. The topic today is common minority ownership interests, minor or major problem. Our all-star panel will discuss whether and to what extent institutional owners of minority interests in multiple competing companies will raise competition issues, and whether any such issues can be addressed by existing law. I'm joined today by Andrew Finch, partner at Paul Weiss in New York, Judge Doug Ginsburg, Senior Circuit Judge for the U.S. Court of Appeals for the District of Columbia, Dr. Fiona Scott Morton, who is the Theodore Nierenberg Professor of Economics at the Yale University School of Management, and Edith Ramirez, partner at Hogan Lovells in Washington, D.C. So to start the panel, Fiona, can you please walk us through the theories of how consumers might be harmed by common ownership?
Sure. I'm just going to put up a few slides with some basic facts to get everybody on the same page so that we can have a discussion, using the same baseline. So here we go. Okay, I've shared my screen, and you can see here just a couple of slides that I want to use to help us understand this topic. So there's a couple of facts that are true now that were not true 30 or 40 years ago. Institutional investors hold more than 70% of the US stock market. One of the 4 largest mutual fund families is the largest investor in almost all of the S&P 500. The largest mutual funds hold, I would say, if you look at the data, 5, 6, 7% of most large publicly traded firms. So that means a single fund would hold 4 or 6 or 7% of a company. It's important to recognize that individuals and sovereign wealth funds can be common owners also, and that we shouldn't think of this problem as being a problem of the index funds. Index funds are actually a small fraction of the category of diversified mutual funds, and both of those kinds of funds typically hold product market competitors like Coke and Pepsi. So the metric that I want to draw everyone's attention to goes as follows. Suppose that the management of a company chose to maximize not that company's profits, but the profits of everything their owners hold. So the CEO of Delta says to himself, I've got a bunch of owners, and those owners hold United and American and Southwest. They don't want me to maximize Delta's profits. They want me to maximize the profits of everything they own, their portfolio profits. What weight should I at Delta put on United's profits or Southwest profits? Okay, now obviously if there's no common ownership at all, then the weight that Delta would put on United's profits is 0. If one common owner owned 100% of all 4 airlines, then United would put a weight of 1 on Delta's profits and vice versa. Okay, so what does the world look like if you use this metric? I've taken this graph straight out of Backus, Conlon, and Sinkinson, and what they show is if you calculate the weight that a firm puts on its rivals, that weight would have been around 0.2 in 1980 and is now up to 0.7 today. So in other words, an owner would like the company's management to put a 70% weight on their rivals compared to 0. So it's a little bit like a merger where you're 70% merged. Would be a kind of informal way to think about it. So what problem does that create? Well, large owners hold stakes in firms that compete in the product market. Delta competes with United, Coke competes with Pepsi. A large common owner has the information, scale, and incentives to engage in corporate governance. And indeed, a lot of large funds promote the fact that they do corporate governance and corporate oversight, and they make sure that compensation is is not too high and appropriately incentivized, and there's not too many corporate jets and so forth. And they also will want to hear from the company about strategy and advise on strategy. So a common shareholder is doing corporate governance and opining on strategy, and that owner benefits from less vigorous product market competition, because when competition is lessened, there's higher profits. Higher profits means the stock price goes up, and if you're a fund owner, you want stock prices to go up, okay, or dividends to go up. So a large common owner has both incentive and ability to lessen competition. That's really the bottom line here. A small common owner might not be doing as much corporate governance. They might have just the same incentive, but less ability to affect competition. Okay, so the meat of the problem then becomes, given the incentive and the ability, what would the consumer harm look like? And in principle, a consumer could experience two effects. They might save via a mutual fund, and so they would value the fact that the mutual fund could hold United, Delta, American, and Southwest, and they would want common ownership. On the other hand, that person might buy airplane tickets and medications and ready-to-eat cereal, and they would want competition and low prices, and that would weigh against wanting common ownership. Probably most of the people watching this podcast, or whatever we want to call it, this event, are going to be experiencing both effects, because we are in an income category where we hold stock and we also buy all these products. But that is not true if you look across the wealth distribution. So think about poor consumers. 60% of the population doesn't own any stock. Okay, so they don't care about diversification at all. They don't own any mutual funds. All they do is consume. So from their perspective, common ownership is only harmful. A very wealthy saver is going to hold some stock, but also foreign stocks, hedge funds, private equity, golf courses, all kinds of assets. And the diversification benefits of a fourth US airline, are going to be basically zero for this saver. And notice that 50%, let's remember, we're a very unequal society, so 50% of wealth is held by the top 1%. So for the top 1% and the bottom 60% don't get anything out of the diversification gains from common ownership. Now, the mutual fund industry gains, but let's remember that that is not the same industry as airlines, beverages, pharmaceutical companies. Okay, those are two different things. So those gains from one can't be used to offset harms in another. Now, what's the empirical evidence? This is a new area. It's growing fast. The airline paper was first. It's now published. I will note that the Trade Association for Mutual Funds, the Investment Company Institute, funded a number of studies by consulting firms that critiqued that paper and a metric used in that paper. And there are several reports and a published paper funded by the industry out there. The new research going forward that I cite here and that's happening now uses different techniques and measures like the one I just showed you from Backus et al. So there are working papers in a variety of industries, and there are some working papers across industries, like showing that more common ownership causes changes in executive compensation. More common ownership actually causes more R&D in industries where there are positive spillovers and the firms are positively affecting each other. And more common ownership causes an increase in rival stock prices. Okay, so I'll close with just pointing out the mechanism for how the common ownership translates into less competition is uncertain. I'll note that this is pretty common in antitrust. I mean, the mechanism by which a merger that satisfies the structural presumption would cause prices to increase is not normally something we specify or know in much detail. We have one clue, which is the paper on executive compensation changing with common ownership. Studying these mechanisms would require confidential data. I've been urging the FTC for a couple of years to carry out a 6B study because academics cannot do this work on behalf of the government or the public because there's too much confidential information that would be required. And it would be a great benefit to everybody to understand this mechanism better. In particular, optimal policy response would really be helped by knowing what the mechanism was. If the lessening of competition were caused by meetings between fund managers and CEOs, then the one policy might be to ban meetings, okay? But if we don't know that, then we are going to be inclined to want to ban common ownership so that we don't have these anti-competitive effects. And I'll just stop there and turn it back to Amanda. Thank you.
Thanks, Fiona. Thanks for that great overview. You know, as you mentioned, there is at least some other economic literature that suggests a lack of these empirical effects from common ownership. And I'd like to turn it over to Doug to provide a little bit of that background.
Okay, so I want to refer back to the Fiona's reference to the 20%, 0.20 to 0.70 value placed on other firm profits, and point out that is a theoretical result, not yet at this point an empirical one. But the common ownership hypothesis should be empirically testable to the extent that competitiveness in a market can be measured, or failing that, to the extent that changes in the competitiveness of a market can be measured. There was some early work on this dating back to the 80s, but the current level of interest in common ownership was really spurred by a series of papers by Azar, Schmaltz, various co-authors, starting in 2016. And they looked at the effect of common ownership on by the major investment management firms, BlackRock, Vanguard, State Street, Fidelity, which collectively, as Fiona suggested, might account for as much as 15 or even 20% of the shares of a publicly traded company, particularly a company in the S&P index, 500 index. These fund managers are common owners, at least to the extent on behalf of that they are acting on behalf of their investors, common owners in competing firms that appear in the index or in whatever composition of the fund it might be. It could be a sectoral fund, for instance, instead of an index fund. So this round of papers starting in 2016 looked at the effects of common ownership on airline tickets in selected markets, fees and interest charges in banks, bank products, and executive compensation. And they consistently found an adverse effect, that's to say that common ownership was associated with higher prices in the product market and weakened incentives for executives to maximize the profitability of their own firms as opposed to the industry as a whole. Now, these and other empirical papers were challenged by other authors who made adjustments in the data and sometimes the methodology used, and found no effects from common ownership. But the studies on both sides of this issue typically depended upon some measure of market concentration that imported all the frailties of the structure, conduct, performance paradigm into their analysis. So more recent papers have looked at alternative possible effects of common ownership, such as the effect on R&D incentives, in one case, the probability that a manufacturer of generic drugs would enter into competition with a branded firm when there's co-ownership, common ownership between the two. The results of more recent studies are mixed, but they tend to favor the common ownership hypothesis of softened competition. Interestingly, there's no body of empirical literature examining the effect of common ownership on the profitability of these nominally competing firms. So what's needed to advance our understanding of common ownership are event studies, of which there have been only a few. The recent paper by Fiona and a collaborator, Professor Baller at Duke, entitled Testing the Theory of Common Ownership, is, I think, by far the most interesting, as well as the most recent paper in this field. And they're finding that when a firm is added to the S&P 500 list, not only its shares, but the average, on average, the shares of its rivals also rise in the index, in the market. And that suggests that investors anticipate that those firms will be more profitable now that their rival is going to join them in the index and therefore have more common ownership, particularly by these large investment management firms. So the study is an extraordinary show of modesty for Fiona not to have mentioned it. But the study is suggestive, obviously not definitive. For one thing, it doesn't deal with antitrust markets expressed explicitly. The shares of rival firms do not necessarily, maybe not even frequently, reflect rivalry in what we would call a properly defined antitrust market. Supermarket chains, the subject of one study, might compete in some regions and not others. Firms counted as rivals might be in additional lines of business also. The one study that looks at what I would think looks like antitrust markets, namely ready-to-eat cereals, looking at it both nationwide and in 10 local markets, found no effect on prices from changes in the level of common ownership. Now, that's not to diminish the value or interest of the Fowler and Scott Morton study, but rather to add that additional work is going to be necessary before anyone can conclude that common ownership has a significant anti-competitive effect in antitrust relevant markets. Fortunately, the authors, and I'm quoting here, plan to improve the paper by developing more precise industry definitions, and they hope that better competitor classifications will sharpen their results. So you can look forward to that. But they also acknowledge, as Fiona just did, I think, that the mechanism that might cause common ownership to lead to higher prices is not yet certain, and more research in this area would be valuable. Now, that's closing the quotation. I would say that an understanding of the mechanism, if there is one, is actually essential before one can conclude that something should be done about common ownership, considering that these funds, index funds as well as others, provide substantial benefits to small investors who couldn't otherwise diversify their risks at so low a cost. Let it go at that for now.
Can I just clarify one thing? So thank you, Doug, for those kind words. And I completely agree about the relevant market, the antitrust market issues and the need for more research. I do want viewers to understand, though, that the Backus and Conlon graph is not theory. That's drawn from what owners own today. So they take the data on fund ownership and corporate ownership, and they calculate what that weight on the other guy's profits would be. So that is drawn, it's not a theoretical construct, it's drawn from the data. Whether managers act on it is a question, but the fact of who owns who is just known. So I just wanted to clarify that. Thank you.
Which I think tells us that the potential harm from common ownership could be very significant, although we're still looking around for what it really is.
Well, thanks, Doug, and thanks, Fiona. It sounds like there's still some room for additional study here, but let's assume for the purpose of the discussion going forward that we could show common ownership results in some anti-competitive effects. For this next question, I'll turn to Edith. Edith, if we think that common ownership could result in anti-competitive effects, are there existing antitrust laws that we could use to address that harm?
Yes, Amanda. So what I'd like to do is to start, first of all, with Section 1 of the Sherman Act, which of course prohibits contracts, combinations, and conspiracies in restraint of trade. Now, I'm going to note that none of the writings that have been discussed suggest that there's evidence of cartel activity or other forms of collusion, but I think it's really important to emphasize the risk of potential liability if fund managers were to be engaging in an effort to pressure or to influence the competitive discussions of portfolio firms. So if there were evidence, for example, of a fund manager urging a decrease in output during investor earning calls or in the course of other direct engagement with portfolio firms, there would be a strong argument that the fund manager was seeking to organize or otherwise facilitate a cartel. And if the firms, in fact, reduce their output, there'd be a prima facie case of a hub and spoke conspiracy in violation of Section 1. And in that type of situation, the key issues, among others, would be to what extent the fund manager's efforts would constitute an invitation to collude, and whether the firms accepted the invitation or were merely acting in parallel, but unilaterally. So in other words, did the fund manager's efforts, in fact, affect the decision to reduce output? Now, of course, Section 1 requires both an agreement as well as a restraint of trade. But it's important to note that under Section 5 of the FTC Act, an invitation to collude is unlawful on its own, even if no one accepts the invitation, even if there's no agreement that's formed. So in light of the increasing engagement that we've seen in recent years between institutional investors and portfolio firms, this is certainly an important area to be conscious of. So before I turn to Section 7 of the Clayton Act, let me just pause in case anybody wanted to add anything with regard to Section 1. If not, I'm happy to move forward. So let me turn to, I think, the more interesting question, which is whether common ownership might violate Section 7 of the Clayton Act. Okay, so Section 7, of course, prohibits acquisitions, the effect of which may be to substantially lessen competition or tend to create a monopoly. A few high-level points. Section 7 applies to both complete mergers and partial acquisitions. And when a partial acquisition will result in the control of the target firm, the transaction is basically treated like a complete merger. But it's also very well recognized that partial acquisitions that don't result in control may nonetheless raise very significant competitive concerns and may require a somewhat different analysis. So the framework that the agencies use for analyzing the impact of acquisitions of minority stakes involving rival firms is set out in the 2010 horizontal merger guidelines that the agencies put out, and it's found in Section 13. I'll note here that what the agencies really are focusing on primarily in that section is cross ownership. In other words, a firm acquiring a minority interest in a rival firm. But the horizontal merger guidelines note that the agencies will be looking at three principal effects that may lessen competition. First, they're going to look at whether the acquiring firm will have the ability to influence the competitive conduct of the target firm, to induce the target firm to compete less aggressively or to coordinate with other firms in the investor's portfolio. And this could happen through voting interest in the target firm, or perhaps through the right to appoint members to the board of directors. Secondly, the agencies look at reduced incentives to compete. Now, typically here, because their focus is on cross ownership, they would be looking at the reduced incentives of the acquiring firm in light of its ownership interest in the target firm. But generally speaking, the concept is to look at reduced incentives. Then third, they look at the extent to which a partial acquisition might lead to access to non-public, competitively sensitive information. The agencies will also consider efficiencies in this analysis, but they acknowledge that partial acquisitions will typically not generate the types of efficiencies that one would find and are commonly associated with complete mergers. Now, let me note that the DOJ and FTC have not historically challenged partial acquisitions of less than a 20% share where they find that there's no evidence of control. So I think this gets to some of the challenge in applying the framework of Section 13 of the horizontal merger guidelines and Section 7 more generally, which is that in the absence of control and at the level of ownership that we're discussing in this conversation, it isn't clear that institutional investors are influencing firms to act anti-competitively. It's also not clear the degree to which firm managers may be taking into account the other holdings of institutional investors and making competitive decisions, or that common ownership is facilitating the transmission of competitively sensitive information. As a side note, I will point out, of course, that Section 8 of the Clayton Act protects against potential information sharing and coordination among firms by prohibiting an individual from serving as an officer or director of two or more competing companies. And that prohibition would also apply if a firm were to appoint agents to serve as officers or directors of competing companies. So in my view, the challenge of bringing a case under Section 7 is that it remains unclear based on the current economic literature. It's unclear how common ownership changes the objectives of firm managers from what the standard assumptions have typically been. And I think this goes back to the conversation that Fiona and Doug framed at the very outset. And in my view, the fact that there is no consensus as of yet regarding the relationship between common ownership and competition, it would be very challenging for the agencies to bring a case under Section 7. So I think I'd come out as Doug did, which is that we need to learn more about this, and we need to learn the degree to which firm managers may be taking into account the preferences of minority owners. Let me also, just before I pause, I'll note that another challenge here is the investment only exemption in Section 7, which provides that the section will not apply to stock purchases that are solely for investment and where the stock isn't used by voting or otherwise to bring about substantial lessening of competition. Here, the main question would be sort of what degree or what constitutes sufficient passivity for purposes of the exemption. And factors that courts and the agencies have looked at are the issue of control. Does the acquisition give the purchaser some level of control? Voting, the level of voting and voting rights is another another factor that's examined, and then the ability to influence more generally. So why don't I pause there and let others jump in.
Yeah, thanks, Edith. I want to just pick up on one thing that you said about cases under Section 7 being hard to bring. There is one example from about 2006 or 2007 at the FTC where they challenged under a consent an acquisition that would have resulted in a company or a fund actually owning 100% of one company and then a minority interest of about 13% of a competing company. That was the Kinder Morgan management buyout. But in that case, you know, again, different from the scenario that we have with institutional investors, there was one side that had 100% control. So I think the cases where you have minority interests on both sides are even more rare.
That's right.
Fiona, I think you wanted to jump in on a point about efficiencies.
This issue of do the small investors who benefit from diversification, how much are we going to credit that as something that offsets any competitive harms we might find? And I'll preface this by saying I'm just the economist, but I have been taught by lawyers that if the harm occurs in a market like mutual funds, and there's people there who benefit from some better organization of mutual funds, that doesn't count if you've got harm in carbonated beverages or in airlines or in seeds, that those are different markets and they have different consumers. And you can't say, well, everybody's being harmed in airlines, so we're going to offset it with some benefits to people in mutual funds. So I'd like to raise that. In addition, I would say the idea that there's a lot of benefit in mutual funds is quite low. For three reasons. Okay, so one, I mentioned the super rich who own most of the stock are not actually getting diversification this way. Secondly, most Americans don't own stock, so they're not getting diversification this way. And third, it turns out that stocks in the same industry that are competitors with each other co-move. So I have a new paper I'm writing with a colleague in the finance group at Yale that shows that if you really want diversification, holding the second and third and fourth airline is not actually very smart. What you want to do is hold a firm that makes plastic or operating systems or trains or something, because those don't move together. So the amount of diversification you get, even if you're in this bucket of a small investor, is tiny. So I would argue conceptually you shouldn't be able to use it in the first place. But anyway, if we got to an empirical weighing, it would be very small.
Amanda, may I comment there for a moment?
By all means.
It seemed to me that in what Fiona was saying, that there were two different themes, I guess. One of which was that the benefits of the whatever benefits there are from the efficiencies of fund investments accrue to wealthier than average citizenry, which is probably true. There are 100 million investors in mutual funds and ETFs, and out of a population of 330 million, that benefit from this to some degree. They may be wealthier than the average, but that's a lot of people. And I don't know that their relative wealth position has ever been thought to be relevant in antitrust policy or enforcement policy. It certainly wasn't when the antitrust division got wind that Sotheby's and Christie's were colluding on prices to their wealthy auction buyers. It wasn't a matter of indifference. But the other point, which is clearly among the things that Fiona said, is that there ought not to be offsets out of market efficiencies, I think would frequently refer to them, not offset benefits in one market against losses in another. That is the policy of the agencies. I think it's arguable. It basically, in a total welfare standard, of course, one would do exactly that. But it's at least a defensible or intelligible principle, let's put it that way. Unlike, I think, the one concerning wealth, if that's what it is.
So let me just correct something. I didn't mean to say that rich people don't get to benefit from antitrust enforcement, not at all. The point I'm making is if you're thinking about the efficiency being additional diversification for savers, that's somehow good, and that common ownership lets us have that, and that's good. 60% of Americans who don't hold any stock don't get that benefit. So that's just not, if you're asking who's getting the benefit, they're not. And the top 1% of the wealth distribution owns half the stocks. They're not getting this benefit either. So the benefit is being narrowly delivered to a set of people who own enough stocks such that they care about it. I didn't make any remarks about how rich those people are, just that it's a small section of the population that's getting this benefit. It occurs in a different industry. And as far as I'm measuring it in new research, it's extremely small. So that was my point.
So we've spent a lot of time here talking about theory so far and really laying the groundwork on that basis. But maybe we can switch gears a little bit and bring Andrew into the discussion. And Andrew, do you have any observations about how the FTC and the DOJ have been approaching these common ownership issues?
Thank you, Amanda. Well, I'll start by saying that Edith did a terrific job summarizing the legal categories through which one would think about these issues, Section 1, Section 7, Section 8. And the horizontal merger guidelines in 2010 reflect that the agencies were thinking about these issues. Since that time, they've continued to think about these issues. If you go back just a couple of years, in late 2017, the DOJ and FTC submitted a paper to the OECD that focused on common ownership issues and said that they would continue to evaluate the new learning and that they would consider the possibility of enforcement action if there was sufficient evidence that a particular acquisition had an effect that would substantially lessen competition. In 2018, the FTC held some hearings and commissioners gave some remarks there that are informative on the subject, and some DOJ folks gave some remarks also that touched on this issue around the same time. More recently still, in April of 2019, the Economic Analysis Group at the Justice Department published a working paper. I believe Eric Lewis worked on it, and it focused on common ownership in airlines and looked at evaluating alternate ownership data and concluded that results on common ownership studies were very sensitive to the data sets. And there have been conversations, as I think Fiona alluded to, of a possible 6B study by the FTC that might also be informative. So the agencies are engaged on the issue. And I think there are a couple of takeaways from what that level of engagement has been. And one of them is that it's an area that certainly needs study. And it's particularly one where it's important to focus, I think, as Fiona said, on the mechanism, because the mechanism is really critical when you're trying to figure out whether anything that's going on fits into a recognized box for antitrust liability, putting aside conversation about whether or not the antitrust liability rules ought to be enlarged or modified in order to take into account a competitive effect that might not currently be captured. But the agencies, at least right now, are focused on, I think, trying to figure out what the mechanism of harm is. And they're, I think, looking at it as there's sort of a spectrum, and to capture and build on what Edith said, at one end of the spectrum, you have common ownership that could lead to active efforts at coordination. Obviously, that could be a problem. Maybe adjacent to that, you have common ownership that might lead to information sharing. Might not be an active effort, but that might potentially have anti-competitive effects. At the far end of the spectrum, you would have common ownership, and there's nothing, no conduct that's going on. It's purely, really, truly, purely passive. And does that have an effect? And what could the mechanism be there? And then I think there's an area that's sort of in between those two poles, which you might ask yourself, is this conduct that might be like conscious parallelism, where people realize, well, there is by assumption no agreement. There's just knowledge about two proverbial gas stations in the desert that are across the street from each other. Don't need to collude because they know what each other's prices are and they can see what the incentives are. Or more recently, people have talked about computer algorithms and can computers achieve an anti-competitive result even if human beings aren't agreeing? And this is a really challenging area, I think, and the agencies are focused on trying to figure out whether or not there are mechanisms there that can be identified and evidence of those mechanisms can be found in a way that could be introduced in court and have an enforcement result.
Thanks, Andrew. Any thoughts from the other panelists on this mechanism for harm? I think it's an important question.
I think the trickiest one, if we were to find it, would be the idea that the CEO is acting less competitively without any instruction. And if the CEO knows that the owners all own competitors and knows that they're going to be happier if competition is less fierce and just carries out a less competitive program without anybody talking to him or explaining it to him or voting a certain way, I think that would be the most problematic, because what then does an enforcer grab onto as the action that is the conduct that's illegal? But if that's going on and we have high prices or less innovation or something is going badly for consumers, then I think as a society we have to think about that. I mean, that's a problem. And we're going to have to find some solution if the antitrust laws don't, on their face, as they're written today, apply very well.
And before we get to a solution, assuming that there is a problem to solve, I think we have to have a way of detecting that conduct. And so, Edith, are there things that the FTC or the DOJ can do from an enforcement perspective that would help them get the information that they would need to even detect if some of this kind of mechanism was happening in the first place?
Sure. I think that the typical situation is a bit different. So I think, ideally, this is an area where one would want more study. One would want an agency like the FTC to engage in a 6B study to be able to hone in on this question that we've been discussing about the mechanism of harm. But putting that to one side, I think areas of inquiry would certainly be trying to ascertain whether or not the communication, the engagement that is taking place between fund managers and firms may be such that it's signaling behavior in a particular direction. So I think that would be an avenue, and that would be, looking very closely at investor calls, earnings calls, whatever information is available about private meetings that may take place. The other area that one would want to examine also is the impact of compensation. That's another potential channel that's been discussed, and evaluating whether there is a less of an emphasis, for instance, in evaluating relative performance in industries where there's a high level of common ownership. So those are two areas where the agencies could certainly get additional information to evaluate impact.
When you were walking us through the potential theories of harm before, Edith, you mentioned potential avenues under Section 7. Is there something that could go into the HSR filing, or that parties could submit as part of those filings that might get to these issues?
Well, like I said, I think to me the key areas, in addition to simply having more by way of event studies or other studies to ascertain if there is in fact a causal effect that's taking place here, I think you'd want to get at issues that relate to, is compensation, is the signaling taking place via compensation, is the signaling taking place in connection with this other engagement. Andrew, I don't know if you want to chime in and add.
Oh, I'd be happy.
Additional thoughts.
I mean, sure. I mean, with regard to the HSR process, my feeling would be that it's not appropriate in this sense. The HSR process is already one where the parties they've got to do enough to get the form together, and then the agencies don't have a lot of time, be it 30 days or maybe if there's a pull and refile 60 in order to make a threshold decision. And trying to introduce this issue into that process would, I think, be problematic and counterproductive, especially because there are so many HSR filings that don't result in investigations, much less second requests. So that's not the place to introduce this issue. I think maybe, if there is a mechanism that's identified or a reason to believe in a particular industry that there could be a real mechanism to be found, and there's some evidence to be gathered, maybe after a second request has been issued, then that might be the time when the agency might take a look. But again, I don't think that there should be a broad fishing expedition every time there might be some common owners in connection with the transaction, because again, even during that time period, the agencies have plenty of work to do and the staff is busy. And so I think that it would need to be a discrete, targeted inquiry when there's a reason to believe there might be a real mechanism and might be proof to be found.
May I comment, Amanda? I actually want to go back to something that came up in things that Andrew and then more particularly Fiona said. So assume that we do have a situation in which we can't find any mechanism, except that it seems that managers, knowing who their owners are, tailor their behavior accordingly and soften competition among themselves. This benefits the common owners, but not the rest of the shareholders. So let's say common owners are 25%, and the shareholders who are not common owners, but are in only one particular stock, are realizing suboptimal, indeed less than competitive returns. I guess it depends upon how the effective oligopoly pricing is allocated, or the profits are allocated among them. But it would create a real possibility that there are disaffected shareholders and an opportunity through the market for corporate control to acquire a company in this position, and on the premise that the acquirer, the activist, thinks that it could be more effective, more profitable if it were competing effectively. We look at antitrust problems particularly, but there are a lot of other things out there in the world, like the market for corporate control and things that inhibit it, like the Williams Act, state takeover defenses and things of that sort, that might be highly relevant if there isn't any more mechanism than what we've described here.
Let me respond to that. So I think what you're saying, Doug, is identifying something that the corporate finance literature calls tunneling. So suppose I've got an owner, a minority owner of a company, and they set up a supplier. They push to have a certain supplier who overcharges and essentially sucks money out to the detriment of other shareholders. That would indeed be a problem. And I think that the corporate control mechanisms that you identify would be a potential solution to that. I think that the authors in the common ownership literature are worried about a slightly different thing, which is more tacit collusion. So if there's a bunch of common owners, funds who all get competition to soften in the airline industry, and prices go up, for example, the small owners who only own Delta are delighted. Delta stock price went up. Delta's earning more profits. So they don't own United or Southwest, but they're still very happy that Delta's profits are higher. So it's sort of a rising tide lifts all boats in that world. If you just have an increase in tacit collusion, then an increase in profits, every kind of owner is happy with that.
Well, I think we know, I don't disagree. I think we know that how difficult it is to envision a remedy for tacit collusion. There was a time when Judge Posner thought that would be a good idea, but he backed away from it further.
Yeah, fair enough.
So if there's actual collusion, we have, the remedies are available. If the management firms are acting as the go-betweens to arrange anti-competitive behavior, essentially they're running a hub and spoke conspiracy, and we have a solution for that. We have to know what's going on.
I think that's
sorry, Fiona, go ahead.
Yeah, no, I agree. I think more research in this area would be really valuable. I'll say in my profession, the juniors are working very hard to write these papers, which is great. And I wish there were more. I really do think the government needs to do more, because the confidential kinds of interactions among these parties are something that's really hard for academics to study.
So we're seeing a theme emerge here through the panel of more thought, more research, more study is needed. But while we're kind of on the topic of practicalities, Doug, I wanted to follow up with you. Just from your perspective on the bench, could you discuss some of the practicalities of litigating a case about common ownership kind of under the way that the regime is today? For example, what would a plaintiff need to do to prove a case, whether that plaintiff is a government agency or a private party?
Yes, I think, frankly, I think that under the statutes as we have them and as they've been applied and interpreted, I can't see a way for a plaintiff to win that case. I mean, the creativity of plaintiff's counsel is not to be discounted. Of course, they may come up with things that I haven't seen in the literature. The arguments that have been made under Section 1 seem to me not really to be taken seriously. The Section 7 arguments are more interesting. But there, I think the reading that we see in the Hovenkamp treatise really reads the exception for investment only out of the statute. Maybe one can find a way to rehabilitate that. Professor Elhoag's approach does leave some room for the exception. It's very narrow. It's not consistent with the case law or the interpretations that the agencies have put on 13F. But that doesn't mean that it's completely out of bounds. But it would be extremely difficult under existing precedent and interpretation, if probably impossible.
Yeah, and another just practical complication that we were brainstorming was, what if you have several institutional investors that are engaged in this kind of conduct, but across multiple industries at the same time? Would you end up in a situation where you have separate cases in parallel, all on the same conduct, or you'd have separate relevant markets? How would that work?
That is to say, legal theory. The particular shape in which it would take seems to be less than even theoretical. I put it that way. But if the agencies do pick up the mantle here and under 6B or otherwise, and dig into this issue more than, reveal things more than we now know, that may bring to light a way of proceeding. If there really is a problem, and if they're, if they can get their hands around it. But it's also possible that they'll have to seek some tailored legislation in order to deal with this.
Could I add something? I think that in some ways what's driving this is the hardest theoretical case. And what probably needs to happen if the law and enforcement is going to advance in this area is that there needs to be a real practical case that can be proven with evidence and communications. I think that's the place probably, if the law evolves in this direction, it will start, which is the agencies, one of them does find evidence of communications, maybe between a fund manager and the firms they're investing in, or maybe it's an internal document that says, here's our rationale for investing in these two companies. And then you actually begin to see the types of mechanism and the types of thought that goes into it. If none of that exists, I think that the cases really aren't going to get off the ground.
There's another consideration that occurs in the same market. It's not, I think it's not an out-of-market benefit. And that is that we would really want to know what the effects for corporate governance are if these investment firms were prohibited, let's say, from consulting, from advising, from discussing things with management. They have a greater incentive than small investors to do so. They have a greater ability to monitor. What we'd want to know is, are they monitoring for good ends or not? But to cut off without fully understanding the consequences, their role in corporate governance would be precipitous.
Well, let's go back to that case that Andrew mentioned, the hypothetical unicorn where harm could actually be shown. And, if somebody could prove that case, what would be the remedy? Maybe to start with you, Edith, is there even a potential remedy under the current law?
I really think the remedy has to follow the harm. And I think the challenge here is that we don't understand what is happening. And to me, assuming that you could establish liability, and I have to agree with Doug that in my view, the investment only exemption presents an obstacle. That's a challenge. So in my view, until we have a better understanding of what the mechanism of harm is, it's hard to come up with a remedy that would be tailored to that, which is precisely what one would want to do in such an instance, right? So without that information, it's challenging to come up with a remedy. I know that Fiona and others have proposed certain ideas, and I'll let her talk about that. But in my view, the traditional approach is one would want to ensure that a remedy addresses the harm. So I'd want to know more.
I completely agree with that. And in my opening slides, I tried to highlight that a bit. If we had a 6B study that showed that it was conversations, then the remedy could be block conversations. If we had a 6B study that showed it was voting, we could change the rules on voting. So I think that's right. Glenn Weil and Eric Posner and I wrote a paper a couple of years ago, assuming that we didn't know the remedy, but that we knew there was harm. And so what would you do in that case? And what we do is we show that the additional diversification benefit to a fund from holding the fourth airline is tiny. Moreover, I'd like to pick up on something Doug raised, which is extremely important, which is corporate governance. If a fund has 4% of an airline, they are doing some corporate governance. But if they had to only hold one airline and they wanted to hold as much in value in one airline as they used to hold in 4, they'd go up to 16% of the airline. Now, a fund that holds 16% of an airline is going to be very much invested in corporate governance. They're going to really be worried about the cost profile, the compensation, all the things that we want a fund to do. So our proposal was safe harbor from antitrust liability if a fund only holds one firm in each oligopoly, as long as they're a big fund. So we said little ones don't matter, make a cutoff so that under that, do whatever you want. But if you're big enough, just hold one, and the FTC would have to annually publish a list of oligopolies. Obviously, a stock ticker does not map neatly into an antitrust market, so you would be doing this in a very rough way. But I think we could get at a lot of the problem in areas like airlines and seeds and beverages or whatever. So you'd hold one airline, and then you, as a fund, would not get the diversification benefit of holding 2, 3, and 4, but that's very small, so that's a very low cost, and I've shown that empirically, actually. And then you get the upside of the corporate governance piece, and then we return to a state where firms are competing with each other because they don't have any significant common owners. So that was our proposal, and I think it's pretty straightforward, but it's a proposal that is completely agnostic as to what the mechanism is. We don't know, but it deals with it, whatever it is.
Let me make sure I understand that. So if I, as a small investor, think that, well, considering the demographics, I think healthcare is going to be a terrific field for investment. I haven't a clue as to how to go about sorting out which companies to invest in. So I will, let's take, say, nursing homes. So I will buy Vanguard's fund that has 18% of one nursing home company. And then I'll put some money into BlackRock, who's got 15% of a different nursing company, and so on. So I have now 4 or 5 different accounts in order to replicate what I would have had today. But each of them is limited to one company. And I presume that applies to the whole family of funds, right? That it couldn't be that they've got a sectoral fund that has an index fund and so on.
Yep. So let me just say, first of all, nursing homes are geographically separated, so I'm not sure they'd make it onto the list of things that the FTC would be worried about.
Well, okay.
So let's stick with airlines. But yes, you could do that. You could buy some United, some American, some Southwest. But of course, that would actually not be very sensible because you don't get much diversification benefit from doing that. You'd be better off buying Southwest, IBM, Google, Plastic, whatever.
Well, that presumes that I would know or be willing to bet on one of them when I don't know anything about the particular firms. I'm not a schooled investment analyst.
Luckily, there are lots of those specialized people out there, and the way the stock market works is that prices are supposed to reflect future returns. So in principle, any one of them has the same expected return because the clever money is engaging in arbitrage to make that.
Ask a question that takes us back to your recent paper. If the investors are anticipating that all of the rivals will now do better because a new entrant in the index, we've got the event study that documenting that. Is there any way to follow up and see, do they do better? Or is it more profitable?
That's a really good question. We have a regression in the paper now looking at accounting profits, and those regressions largely confirm what we're finding. The problem with accounting profits is they have all the problems that economists normally complain about with accounting profits. It's also, of course, going to be really hard to look out any length of time because the noise in the environment just swamps these kinds of effects. So I think what you've said is a very good idea, and we've tried to take a step in that direction, and there's some natural limitations.
I'd just jump in if I could for a moment and say one thing, which just builds on, I think, something the judge said, which is that there are a variety of investment strategies here, right? You could look at a sector and say, I don't know which one to choose. I'm going to choose all of them. Or a completely passive investor might say this industry is concentrated and has high profits, and I don't know which one to choose, but I'd like to be an investor in that industry. And I think in the absence of, again, the audience may get bored of the word, but the absence of a mechanism creating a regulatory overlay that tries to police all the various possible rationales for making an investment, whether they're smart ones or not, I think is a remedy that risks being far greater than what we've actually identified as being the problem. And if you really peel it back, I think a lot of this is coming out of the inability to distinguish here between correlation and causation. I really do, because in many ways we're talking about, well, this is the ownership structure and here we seem to see something, but are we inferring an effect? And the inability to identify a mechanism should give us, I think, some skepticism about whether or not there's an appropriate basis for regulatory intervention here.
So I need to push back on two of the things you said. First of all, the econometric papers in this literature are exactly dealing with causation. They're not dealing with the mechanism, but they're dealing with causation. So that is, I think, an invalid critique for a lot of these papers. But secondly, what you said is we shouldn't jump in with regulation now because we don't know what the harm is. I agree. Nobody said we should. I think the point here is to say, if we found harm, what would the response be? And saying at that point, well, we found a lot of harm, but really I'd like John Smith to be allowed to hold both United, or Vanguard, to hold United and American and Southwest, despite the fact that that's harming tons of consumers and we know why, strikes me as not very in sync with the spirit of the antitrust laws. I mean, if we get to a point where we have harm and we understand it, then that's the reason that we constrain behavior. That's kind of normal, but we're not there yet. I fully agree with that.
Yeah, I think we agree that we're all agreed, I think, that we're searching for the mechanism or mechanisms.
Right,
So,
but Spirit won't do it. We're gonna, if the law doesn't cover it, then we'll have to be either let it go or have a change in the law.
So I think one again, coming back to the theme of our panel here, there's a lot of uncertainty and a lot of need for some additional thought and research on this. But what does that mean for companies that are in the thick of it right now? Andrew, you're recently back in private practice. Do you have any advice on how investors should be navigating these issues?
I have a couple of thoughts. I mean, in some ways, if we go back to the spectrum, the one side of the spectrum that has the explicit collusion or consulting and cajoling and information sharing where there could be a Section 1 problem, I think that's a legitimate area to think about compliance and how investors might think about monitoring and paying attention to the types of information, because to the extent the agencies may be looking for issues there, that's one way to possibly reduce risk. I think that another thing that's important is maybe understanding the rationale for an investment. And that's something else that could be thought about if a firm is, if an investor is actively investing in competing corporations, it might make sense to just make sure there's an understanding as to the rationale and the strategy behind that. Those are two things that I think may actually help firms that are in the real world trying to navigate these issues.
Thanks. So we started the discussion today with the theory, and we talked about the remedy, and then we talked about advice. Before we wrap up today, any concluding thoughts from any of the panelists?
I think it's an exciting area and people should be watching the literature and watching what happens in the marketplace, because I think we're going to see developments and new learning, and it'll be really interesting.
I agree with that.
And hopefully the agencies will jump in and continue to be looking at this issue, and hopefully we see a 6B study from the FTC soon.
Okay,
Thank you all.
I second that.
Yeah, well, everyone, thanks for listening. I think the bottom line is stay tuned. There will be more coming down the pike on this issue for sure. Thank you for joining us today. I look forward to seeing all of you tonight at our virtual farewell reception. And with that, I'll turn it back to John Roberti in the virtual spring meeting studio.
Okay, thank you, Amanda. And we are back. Very, very interesting discussion today. Megan, maybe let's start with you. What were your takeaways from today's discussion?
So my biggest takeaway is that there is clearly the need for more information and study in this area. I think that the panelists all agreed, even if they thought that the outcome of that study might be different, that we just don't have enough information yet today to make conclusions. I don't know, Amanda, did you have additional thoughts on that?
I think that I agree with that point. That seems to be the biggest takeaway here, and the panelists all came to a consensus on that. As a corollary to that point, I think the next question that we need to consider is who is best equipped to deal with those additional studies and the fact gathering? Is it the academic community? Is it the agencies? Is it the discovery process? This seems to be the next big step that we need to take here in order to advance the ball.
Yeah, I totally agree. And to put a little bit finer point on exactly what I think we need to be looking into, I think there are two big picture questions that need better answers. One is if there is anti-competitive effects, which I think I heard Fiona say basically, yes, there is, and Doug take a little bit more of a not so sure view. It does look like there might be some kind of harm, but we need to know what kind of harm that is and if it is indeed antitrust harm. And the other, which we heard over and over from all of our panelists, was that the mechanism, what is the mechanism by which we can say that there are any anti-competitive effects? And there were some suggestions thrown out there about potential mechanisms like meetings, information exchange, etc. But there really hasn't been any studies to link those anti-competitive effects to a particular harm. And that's probably why we didn't hear any recommendations on enforcement. I think we would hear more recommendations on enforcement if what we knew was clearer, but were just a chorus, I would say, of calls for additional information. And one thing I did think about, Amanda, I love your views, is that there was a little bit of hope that the antitrust laws do still reach at least some competition concerns that could be raised by common ownership. For example, Edith noted that there is a way to deal with collusion facilitated by common owners under Section 1 of the Sherman Act. But I think you noted that the discovery process would be one of the ways to pull that information together. And I think that in a Section 1 case, that could be one of those opportunities. Would you agree with that?
Megan, that's a great point. And I think that as Edith and Andrew commented, we'll have to perhaps be looking to internal documents of either investors or documents at the firm level. But backing up from there, John, Megan, I think another key point here is that this issue should really command our attention. Based on the stats that Fiona went over at the outset of the panel, if there's an antitrust problem here, its scale could be truly all-encompassing and quite a challenge, and it could touch on almost every industry in our economy. And given that sheer scale, it seems important that we get to the bottom of these questions sooner rather than later. So, John, you and I should talk about whether your programming schedule might allow for a sequel to the panel in the next year or so.
Amanda, we would love to have you both back on Our Curious Amalgam, and we will get that scheduled. So, Amanda, Megan, thank you for your great analysis. Really, really helpful. Amanda, Norton in particular, thank you for putting together this panel. You did all the hard work, and it really paid off. We also want to thank Amanda Waite and the panelists for all of their preparation. Very, very valuable. Most importantly, we want to thank those who are watching, our members. Thank you for listening. Thank you for tuning in to the virtual spring meeting. And until we speak again, please be well and be safe.